Right. So, welcome everybody. Good morning. We've seen we are almost 80 people around. So let me thank all of you for being around. I think we have a variety of people that are following this roundtable. We have the students of my course of comparative private law and Paola Yamicheli's course on foundation of private law, which are the sales students, student of the bachelor program. But we also have some PhD students, and we have a variety of colleagues, both of the Faculty of Law of Trento and of other universities around in Italy. So let me thank all of you. Just to let you know how things are working, because of course this method of webinar is something that has taken some time to develop. The roundtable is recorded, and it's going to be set afterwards on the website of the faculty, because a few people have told me that I can't participate, but that they would be very interested in listening and seeing the presentation. So only the speaker's presentation will be available later on the website of the faculty, not the question and answer part, because this would require other kind of technical arrangements. But the idea is that our three guests are going to make a presentation between 20 and 30 minutes each. And then we're going to have quite a lot of time in order to have questions, because this is meant to be an open roundtable where participants are going to share their views with students and colleagues. So we're going to allow quite a significant amount of time for questions. Right, so much for the technical part. Now, let me first thank you warmly, our presenters today. They have been very kind to accept our invitation. We were looking forward to see them in person in Trento. They're all friends of our faculty and part of our community. And it's really a pity that we cannot manage to be there together. But I think it's a sign on how strong the bonds are, that we, in spite of all the difficulties of this current period, we managed to keep things going. So in fact, both Professor Van Erp and Professor Biel have been also participating to our respective courses. So they've been working continuously, and Professor De Vries, of course, also has a very strong relation, particularly working with Elena Ioratti, who unfortunately cannot be here with us today. And so the idea of the roundtable is somehow to use their expertise in order to kind of having a perspective on some subject that have been recurring coming in our courses. Now, Paola, of course, in her first year course on Foundation of Private Law has a very broad focus on all aspects that are related to private law. My course on comparative private law rather narrows down the focus to the three main partitions of property law, contract law, and tort law by analyzing some specific issues more in detail. But in both our courses, we have underlined the fact that while traditional comparative law focused just on national legal systems and partly on international law, in fact, our European system are now part of a much broader web of rules where EU law is actually playing a very important role. And the interesting feature is that this is a very dynamic system. It's not set once for all. So the way in which EU rules interact with national law is changing over time. And the changes are connected both to the internal changes inside European, the national system, but also in the changes that have taken place, very relevant changes over time in EU law. And the interesting feature is that while in general, at a superficial glance, the focus is on harmonization, the fact that having European EU law means that there's more and more convergence. In fact, when you look in more detail, you can see both trends toward convergence and divergence. That is, the insertion of EU law is not a one-way, one-dimensional kind of intervention. It also sets a number of frictions, and these frictions are solved in a variety of ways. And in fact, I think that the current crisis that we are experiencing because of the COVID outbreak is something that is challenging all parts of our societal life, and law is one of that. So in fact, I think by looking at the slide, I think that Hugh will mention something about the effect of the COVID crisis on contractual rules, particularly rules on force majeure and hardship. And there you can see that partly EU law is providing solutions, but at the same time, there are national resistances. So I think this subject matter is very interesting because it allows us also to see what is actually unfolding under our eyes in these days. So with that, I stop because I think that the most interesting part is by listening to our guests. So we start with Professor Siebe de Vries from the University of Utrecht, who is going to talk about EU law, fundamental rights, and private actors. So thank you very much for joining us, and you have the floor. Micro? Okay, there you go.
For having invited me to join this roundtable. And I'm also, I would like to emphasize, I'm very happy that things have improved in Italy when it comes to the Corona crisis in the north of Italy. It seems that you are heading also for the right direction. So I'm very happy to read that, and of course it's very unfortunate I can't join you physically, but at least digitally. And that is increasingly common, as you mentioned, but also even with your colleagues within your own country, of course. We have video conferences and video calls continuously every day, which is, by the way, a challenge in itself, and that you are not getting too tired of the screens. So maybe we should find some cure for that as well. So I'm very honored to be here and to have this presentation. And I'm a little bit perhaps the ugly duck because I'm an EU lawyer. So and I know, although that is changing, and I know also that in Trento that might be somewhat different, but sometimes there's you could say kind of frictious relationship between EU law and private law, and they do not always seem to like each other so much. And we had a discussion, actually, I think it was 2 days ago, with some board members of the Netherlands Association for European Law, discussing the recent judgment of the Bundesverfassungsgericht in Germany, which you probably have heard of. And I'm an honorary judge myself, but then within the field of administrative law, so I have not a focus on private law that much in my practical life. But one of my colleagues there in the board, he is a judge in the field of civil law, and he said that there's still so much reluctance and hesitance on the part of judges, for example, to, you could say, to either refer questions to Luxembourg or to deal with case law of the court in Luxembourg. So sometimes there's still frictious or tense relationships. So perhaps I'm a little bit the ugly duck. But what I would like to do very briefly, a brief overview of developments in the field of EU law, fundamental rights, and duties, rights and duties imposed on private actors, and well, to what extent we can see some harmonious development in this respect, particularly in case law of the European Court of Justice. Oh, I just have to press this one. Why is this relevant? That is maybe the first question. Now, first of all, I would like to zoom in later on a little bit on fundamental rights in EU law, because fundamental rights in EU law, their importance has grown, you could say, during the last 10, 15 years considerably. Of course, to a large extent, perhaps due to the binding EU Charter of Fundamental Rights, binding upon EU institutions, but also on the member states whenever they act within the scope of EU law. Of course, a question that I will deal with it at the end of the presentation are these fundamental rights that we find in the EU Charter also binding on private actors, which are not mentioned by the EU Charter of Fundamental Rights. Now, secondly, why is this relevant is because of an ongoing, you could say, blurring distinction between the public and the private domain, and which is, you could say, further stimulated by technological developments and digitalization. For example, tech firms like Google, Facebook, Amazon, they play a major role in society. And this role may only increase perhaps of the corona crisis as well. Think about the development and the use of so-called corona apps. A discussion that is now taking place, or there are also, it's being used or it's being tried in a number of member states. So these two developments, the growing role of EU fundamental rights, as well as the blurring distinction, you could say, between the public and private domain, they may call for a renewed approach to fundamental rights and their application to private parties. After all, fundamental rights, in principle, relate to the vertical relationship between the state and the citizen, with a view to constrain state power. Now, and then I will see whether this approach is based on developments elsewhere in EU law and in the case law of the European Court of Justice when it comes to application of EU law to private parties. Now, I made an analogy, and Louisa knows me probably, so that's why I have this picture on my second slide with Piet Mondriaan. He was quite a well-known Dutch painter at the beginning of the 20th century, and this is his composition with yellow, blue, and red. And I make this analogy or comparison with the court's case law, and that can also be perhaps categorized into three stages. And during the first stage, the court, similarly to the painter, draws vertical and horizontal lines. It defines and demarcates the conditions under which European law has vertical and horizontal direct effect. During the second stage, the painter uses colors to fill in the blank spaces. Now, these colors, these different colors, may well reflect the different status of rights under EU law and fundamental rights, and the extent to which they have been given shape and meaning in the case law of the European Court of Justice, and ultimately the extent to which they are being granted horizontal direct effect. Now, these concepts I will briefly explain in a minute, because maybe not all of you are aware of what this means. Now, during the, you could say, the third and the final stage, there the painter, Piet Mondriaan, has an outlook or looks out for harmony. Now, the Court of Justice also seems to work towards a more seamless web of judicial protection for all persons having rights under EU law. Now, and I will have a brief look whether that's the case, and that could also be a discussion point, and whether actually that is desirable to have this seamless web of judicial protection. And thereby we should not forget, now turning to private law, that from the perspective of private law, the freedom of contract and contractual autonomy should be safeguarded rather than being undermined or jeopardized by EU law, EU fundamental rights, or EU law in general. So, turning then to the first stage, drawing the vertical and horizontal lines. We first have to know a little bit more about EU law, its fundamental principles, and how private parties derive rights from EU law and are imposed obligations are being imposed obligations in the first place. Now, the court started to draw first vertical lines. Now, as you probably know, if you have a right under EU law and your own state or your government or a public authority curtails or denies you this right, which is contrary to EU law, you can go to your own court and claim the right vis-à-vis the government or the public authority. And this is called vertical direct effect. Now, already in the 1960s, in the famous Van Gent en Loos judgment, the European Court of Justice held that the EU legal order is an independent, autonomous legal order, which is intended to confer rights upon individuals. And it's not merely a legal order or an international legal order between states. No, it also grants individuals rights. If provisions of EU law are sufficiently precise and unconditional, you can rely upon them before a national court. So we know, for instance, that the 4 fundamental freedoms on goods, persons, services, and capital that constitute the EU single market have vertical direct effect. Then the court started to draw the horizontal lines. I should go back to my other slide, I think. Oh, sorry. Here something goes wrong. I'm here. Yeah, sorry. So what if private actors, private parties, companies restrict rights that persons can derive from EU law? Could you in a court, in a national court, address these private parties directly on the basis of European law? Now, for some EU rules, this has always been the case. Think about competition law. Competition rules, like the cartel prohibition, which prohibits, for instance, contracts between private parties that restrict competition on the internal market, these have so-called horizontal direct effect. As a company, as an undertaking, or as a consumer, you can invoke these rules before a civil court vis-à-vis other companies engaged in actually breaking the competition rules, in breaking the antitrust rules laid down in the EU treaty. Now, for other rules of EU law, this has been less clear, as they are mostly presumed to be addressed to the state, to public authorities. Now, we know that in the famous Italian case, not far actually located from Trento, the Angonese judgment, the Court of Justice held that the free movement of persons provision could be invoked by a person, by a citizen, against another private party. A private Italian bank in Bolzano implementing a discriminatory language policy could be held responsible directly in the Italian court for restricting the free movement of workers, one of the core fundamental freedoms of the EU single market. And this means that the free movement of workers provision does not only have direct effect in a vertical, but also in a horizontal relationship, horizontal direct effect, in other words. Now, in Angonese, it concerns a discriminatory policy on grounds of nationality. In other cases, the court held that private parties cannot restrict market access, however, only under certain conditions. For instance, that the private party has a certain dominance or holds a certain market power over other individuals. So there are provisions of EU law that do not only confer rights on citizens, private parties, but can also impose obligations on private parties. And next to the competition rules, private parties have also duties under for example, EU free movement law to respect the principles of non-discrimination and market access. And this is particularly important in the digital single market, where tech firms hold dominant positions, exercise power, data power over large groups of citizens, consumers and smaller businesses, and could thus be held accountable for an infringement of the EU fundamental freedoms next to competition law. Now, what about fundamental rights that we can find in the treaty or in the binding EU Charter of Fundamental Rights? Is the court indeed filling in the blank spaces, like Piet Mondriaan with his colors yellow, blue, and red? Now, first of all, the 4 fundamental freedoms constituting the EU single market could be seen as fundamental rights in their own right, partly because they include, as a general underlying principle, the principle of non-discrimination on grounds of nationality. And the free movement of persons and services provisions have also been recognized as having horizontal direct effect in the court's case law. Secondly, already in the 1970s, the Court of Justice held in the famous case De Vrenne that the principle of equal pay for men and women, enshrined in Article 157 of the Treaty of the Functioning of the European Union, has horizontal direct effect. And maybe you recall this was actually a dispute between the stewardess, the air hostess De Vrenne, and her employer Sabena, the at that time still existing Belgian airline company, a private law company that treated the female workers actually worse than her male colleagues. And it did not only concern a dispute on salaries, but also generally on working conditions. And I think the whole procedure before the national courts and the Court of Justice took 10 years before she could claim her rights. This is quite a long period of time, of course, so she could definitely be described as a heroine, because as a result of this case law and the whole equal treatment actually legislation came into being in the EU with significant effects for the position of women. So that's a second important development. Now, thirdly, in a number of cases, the European Court of Justice also established that the principle of non-discrimination on other grounds than nationality and sex, like in the case of De Vrenne, specifically age or religion, which we can find in the EU Treaty and the EU Charter, and this all started with the Mangold case law, could be relied upon by persons in a court vis-à-vis their employer, if the principle of non-discrimination on other grounds than nationality had been subject to EU legislation, had been elaborated by EU legislation. Now, fourthly, and most recently, the Court of Justice has unequivocally established that private parties, individuals, may have to comply with fundamental rights that are laid down in the EU Charter, fundamental rights, beyond the principle of non-discrimination. Very interesting case law like the Bauer, Max Planck, Cresco cases, where private employers have been imposed, you could say, obligations or duties when it comes to social rights. So beyond the principle of non-discrimination, in this particular case, the right to an annual period of paid leave as enshrined in Article 31, paragraph 2 of the EU Charter. And Bauer is interesting because actually it concerned 2 cases, joint cases, one actually dispute between a private individual and a public employer, and one dispute between a private individual and a private employer. And here you could clearly see that if the court would not grant horizontal direct effect to one of those fundamental rights, in this particular case, Article 31, paragraph 2, that would lead to two different outcomes in exactly, you could say, the same cases. So a very similar dispute. Now, the fact that Article 31, paragraph 2, the right to paid annual leave, which is a fundamental social right, according to the Court of Justice, is mandatory and unconditional in nature, made it suitable, you could say, to be relied upon in a dispute between private parties before a national court. And this is somewhat revolutionary because we are talking here about the EU Charter of Fundamental Rights, and I started off my presentation by saying, yeah, but these fundamental rights, they are addressed to the EU institutions and to the member states, according to Article 51, paragraph 1, and private actors are not mentioned. So a number of authors, but also even the Advocate General said, well, the Charter cannot generate rights and duties in horizontal disputes. And the court set that argument aside in this case law. Now, how far could we extend this case law to other fundamental rights? Now, we have already seen case law, for example, which is also very important and relevant for private lawyers, for example, where the protection of intellectual property rights are at issue. Vis-a-vis, on the other hand, the rights of privacy and the freedom to conduct a business. An important case, I just mentioned the name, but I can later on, if there are any questions, I can clarify this, is Scarlett Extended, which concerned actually the rights on the one hand, the intellectual property rights on the one hand of musicians that were being protected by an organization protecting the intellectual property rights or safeguarding the intellectual property rights of musicians on the one hand, and on the other hand, the rights of consumers and internet pirates, allowing for the illegally downloading of music and their rights to privacy, data protection, and the freedom to conduct a business. Another interesting case, of course, is Google Spain, where Google is being imposed obligations under Article 7 and 8 of the EU Charter of Fundamental Rights on privacy and data protection to allow a data subject the right to be forgotten or the right of erasure. Now, I will not go into the details of this case law because we have two other speakers, but if there are any questions, I'm happy, of course, to further elaborate on this. So we see that these blank spaces are gradually filled in, you could say, when it comes to the horizontal application of EU law and the horizontal direct effect of EU law, with various rights that we can find in the treaty, but also in the EU Charter of Fundamental Rights. Of course, this all under conditions which I have not really dealt with now, but if there are any questions, I'm happy to answer them. This is, however, not the end of the story, not the end of the narrative that I was going to, that I'm having now. We see indeed a development towards a more seamless web of judicial protection. And the growing acceptance of horizontal direct effect and increasing, you could say, obligations imposed on private parties may be welcomed from the perspective of a more blurring distinction between the public and the private domain. And the role of private actors, for example, that they play in the digital marketplace. But it raises at the same time questions on legitimacy, on accountability, and private autonomy, of course. Are there, for example, exceptions that private parties can invoke justification grounds if they're being confronted in a dispute, a horizontal dispute with rights deriving from EU law and EU fundamental rights. Normally, the system of EU law only allows for justifications that relate to a public interest, because you could say the established case law of the Court of Justice, most disputes are between citizens and public authorities. And the exceptions that we find in the treaties, they all relate to non-economic public interest and not to commercial interests of private parties. Normally, we would say, well, states cannot invoke economic grounds as a justification because this amounts to protectionism. But what about the private parties' commercial interests? Can they be taken into account? Now, the EU Charter is in that sense quite an interesting document because it contains also rights, particularly interesting for businesses, for private party, like for example, Article 16 of the EU Charter, the freedom to conduct a business, which seeks to protect private autonomy and the commercial interests. Peter Oliver wrote a brilliant actually article on Article 16. How far, another question is, how far do the obligations reach for private parties? For example, when it comes to, and I focus now a little bit on the digital single market, when it comes to responsibilities, even for very big firms like Facebook, to respect privacy or to protect people against hate speech. And what about then the freedom of expression? Can we allow these private parties to balance these conflicting fundamental rights that they are being confronted with, perhaps in a court? Does that not lead to a form of self-censorship? How far do the obligations reach? Well, my view is, and I come to a conclusion now, is that we have to find innovative solutions to deal with these conflicting situations or these situations. And perhaps we can find them in civil law, and even in civil law that dates back from a long time ago, and of course from your country. And then I talk about Roman law. Think about the actio injuriarum, for example, a Roman law remedy which served to protect the non-patrimonial aspects of a person's existence, their physical body, their reputation, and their esteem. And this may perhaps include privacy or the protection against revenge porn or hate speech. So perhaps we find solutions indeed in the civil law systems themselves, which in a case of a dispute between two private parties can be used to remedy breaches of certain fundamental rights. Thank you very much.
Thank you very much to Siebe, to Professor De Vries. This was, I think, an excellent start because you really gave a broad overview of all the elements that are at play. That is, it's a vertical problem of the impact of EU law on national law, but it has become very much a horizontal problem of defining exactly what is the role of private parties. It's also a kind of diagonal thing, that is what it means that the four fundamental freedom and the movement implies that you might have rules from other national legal systems that are directly applicable inside other member states and the possible conflicts that arise. And I was very interested by your final remarks because in the last part of our course on property law with Professor Van Epp, that was exactly the issue. That is, this new situation, how far can it be solved by using old categories that might be in fact more flexible than we have initially thought, either going as back as Roman law, but even more modern law, where instruments that were not made for a digital world might still have inbuilt flexibility that might allow them to be redefined and readjusted to the current needs. and how far, on the contrary, this is a completely brand new world, and as a consequence, concepts and the institutional framework is simply not fitting anymore, and we need to devise brand new solutions. So I think that's a theme, a recurrent theme that is underlying all major areas: tort law, property law, contract law, privacy, fundamental rights. So I'm very grateful to you that you made such a beautiful, broad overview, bird fly over EU law and private law, and I think this is going to be very helpful for the continuing part of our session. So thank you very much again.
Thank you, Lisa. I will stop sharing now.
Yeah, stop share your slides, and then I'll ask to Professor Van Erp to try and share his screen with his slides, if that works. And then I'll give you the floor to him, who's going to talk about data, artificial intelligence, and land registration in European law.
Right. Okay. Well, Luisa and Paula, thank you very much for inviting me, and it's a pleasure joining. What I will do is talk about the impact of new technologies on the law, particularly property law. And I'll take land registration as a specific example.
Chef, okay, now we see you. Thank you.
Okay, all right. But before I do that, just to point out how fast technical developments go. And it is a phrase I keep repeating every year that I talk about this topic, and that I give talks or lectures on this, that developments go fast, but they do go fast. We now have, instead of 4G, 5G. So that will speed up connections. We have what they call edge computing. That means that the computing, so the analysis, storage and analysis of data, will no longer take place in large data centers, but in local so-called micro data centers. And that will speed up the processing of data and the storage. And that is important for the Internet of Things, because all the information that comes onto the network through the Internet of Things has to be shared all over a huge network. And the idea is that by having it in a smaller network, it's easier to store, easier to analyze, and it makes also data processing easier and quicker. And that might be important not just for the central heating in your house, which is governed by software and through IoT mechanisms, but for farmers who are farming their land and are collecting information about the soil quality, and want to use that information as quickly as possible. So it has to be collected, it has to be stored, it has to be analyzed, and then a feedback to the farmer. And to do that, you need speed, you need bandwidth, and in fact, these new technical developments make that all possible. Another development is what they call hyper-automation, and that is that the connecting of various software solutions goes faster and faster with the help of quantum technology. And in quantum technology, something is happening that, well, it's very difficult to follow, but traditionally when it comes to data, we say data is minuses and pluses, zeros and ones. But in quantum technology, there is no longer a 0 and a 1. There is no longer a minus and a plus. It can be both. And that makes all sorts of new developments possible, very fast analysis. And well, what will that do to the future development of software technologies? We have the semantic web, where computers, with the help of artificial intelligence, analyze what is going on the internet, and based on that analysis, then act. And not because a human tells them to act, but because they themselves tell them to act. And these developments are fast. I can only describe them now just in a few sentences. I know it's superficial, but when you read about them, it is like, well, and it's what I said in earlier talks too, it's like reading about science fiction becoming true. And this is the world in which we now also live. And I think, to connect with what my colleague Giurisprudenza said from Utrecht, yes, there are hesitations about the impact of European Union law on national law by, say, judges sometimes and other practitioners. But I think that these technical developments simply will bypass the whole debate about the effectiveness of EU law, because data by definition are borderless, they are flowing, and they affect us all. And looking at the last of the developments I wanted to describe, the so-called serverless society. In that society, in fact, the data are spread out over several servers. No one knows as a user where certain parts of your data are. They are just connected and assembled when you as a user want to use them. These servers could be all over the world at the same time. So where is data located? How do you decide which law applies? I think it will be more and more in the interest of all of us that we agree on not just regional, but even global standards here. But that is not easy, to put it carefully. So it's not surprising that the European Union has published a whole series of policy papers recently in February on the impact of this, what they call the new data waves, and particularly artificial intelligence, on the impact of the economy, the internal market, but also how to regulate this. Now, the difficulty with these policy papers when you read them is that for the most part, they are about strategy. So they are political in nature. They are about defending Europe against, let's say, other bigger economies like the United States, like India, like China, to some degree Russia. So they are about defending us against. But at the same time, these papers also show clearly what the impact on the economy will be of these new data waves of artificial intelligence. And consequently, because of that, what the impact on regulation will be, how to deal with this massive flow of data. And one of the main concerns of the Commission in Brussels is that certain companies will become so big and so influential that they simply can sit on the data, do not share them, and use that power, let's say, for economic purposes. And the concern is that in certain countries, that power would then be used for political purposes. So the European Union wants sharing of data. And then the question is, how do you do that from a legal perspective? How do you share data? And in fact, when you talk about sharing data, your first question is, well, is there something that you can share? How do you share data? Because data by definition are intangible. You can copy them easily. So how to do that? Now, what I will do is I will take as an example land registration, because that, for me as a property lawyer, shows clearly what is going on here. Now, historically, a land registration system already was about information. It was about information regarding land and buildings, rights regarding those land and buildings, and the people having those rights. So in that sense, land registration has never been about the object as such. It has been about information about that object. The thing historically, however, was that that information was in written ledgers. And if you wanted to get the information, you had to come to the office of the registrar in person. Now, what digitalization has done, and the interconnectedness of the world as a result of the internet, is that this information is now available in easily copyable format. You can approach it from anywhere. And because it's now available in an easy to copy format, you can do things with it which you could not do before. You can combine your information with other information. You can combine databases. You can combine information on land ownership with geospatial data. You could do that before, but it took time, a lot of time. But now it doesn't. It's all available in electronic format. It can be done quickly. You use fast computers. The software is developing. So gradually, land registries are being perceived not so much as sources of information for private persons or right holders, but they are more and more seen as, let's say, sources for data mining. And the moment you look at the land registry as a source for data mining, then suddenly your perspective completely changes. It makes a land registry interesting for investment purposes suddenly. And as I told the students in my course, what we see happening in countries like Canada and Australia is that governments now also discover that the information in a land registry is very valuable, that they could sell it, and that they in fact privatize the land registry by selling it to an investment company. The government gets a lot of money, and the investment company is interested not so much in us as private citizens, whether we get accurate information. They're interested in the information as such, because it can be merged with other information, and in fact, they can, what they say, add value. They can create a value-added supply chain. And the Commission in Brussels is seeing this happening. Generally speaking, on the continent of Europe, we are not happy about this development. We consider land registries to be public institutions, institutions that should not be sold, not be privatized. But in the UK, this debate is going on. It already was going on before Brexit, and I'm sure the debate will come back. Now, what I said, the Commission in Brussels is seeing that this is happening, that data are valuable, are more and more valuable, that data are sold, are traded in. And then we should realize, and I know if privacy lawyers are not listening in, that they might worry about my statement, but they should not, but in a way, they should perhaps. What we see happening is that the GDPR, which is also there to protect us as private citizens regarding our personal data, is more seen as a tool to decide which data cannot be traded in than as a tool to protect us in our privacy. And in fact, when you look at the GDPR, you in fact see that one of its purposes is to make clear that you cannot trade in non-personal data. But the regulation on the free trade in non-personal data, in fact, makes crystal clear that for the rest, all data will be tradable. And we have 4 freedoms within the internal market, as my colleague Sibbe de Vries clearly explained. But the Commission now says basically we have 5, not just goods, services, persons, capital, but also data, freedom of data. And how to deal with that freedom of data in a well-regulated way, looking at European interests. Now, one major concern for the European Union here is the impact of artificial intelligence. There are debates going on that if you do not follow them might seem almost alien to you. There is a debate going on, and there is already case law and decisions by administrative authorities on whether artificial intelligence can be seen as a subject under intellectual property law. So if a computer program designs a painting or designs a piece of music, so not a human being, but the program itself, in such a way that you could say, well, there is some creativity going on there. The question is, who has the copyright? Is the copyright in the hands of the programmer? Is the copyright in the hands of the company that has that software running on its computers? Or is it the computer itself? Now, some say this is a debate comparable to, well, accepting legal persons as persons recognized in a legal system. So we have natural persons, legal persons, corporations, and so on. But it's different. In the case of legal persons, we still have human beings deciding about, well, shall we conclude a contract? Shall we invest? How do we manage the funds? It's human beings. But in the case of artificial intelligence, it's the algorithms themselves that decide. The human being starts the process, but the question is, does the human being control the process? Is it a human process or a machine-based process? Now, so far, the decision that I see all say it must at the end be a human being who is entitled to the copyright. We cannot accept that a computer program is given a copyright. That in a way is not so much a legal discussion, it is a question of ethics, right? We don't want to give away control over our destiny to computers. At the same time, we should not ignore what AI can do, that it can speed up the analysis of data, that it can add value to data. And the Commission basically in Brussels is saying both. They're saying we have to take care that fundamental human rights are protected and that we are not run, that our lives are not run by computers as such. At the same time, we cannot deny the impact of IT on how data are being processed and analyzed. So what we see is when you read through these policy papers, and for a lawyer, what I said, they're not easy to read. For the most part, they are about what is happening at a technical level, what is happening at an economic level. And then the words come, well, what we have to regulate. What we see, at least what I see as a property lawyer, is that at the end, the papers are about who controls and manages in that way, or that sense, owns the data flows and the data as such. Because what the European Commission wants is to avoid that data basically are collected only by a few companies. And then those few companies sit on those data and basically on the basis of the saying, you know, might is right. So I have them, so I tell you what will happen. Basically dictate what is going to be done with those data. So what the Commission wants is that the data are shared. Of course, they focus on non-personal data. So data not protected by the GDPR, but we should all realize that, you know, how quickly it goes when you go to a website, that website asks for your email address, you tick the box, you say yes because you want the newsletter or whatever, how quickly we are willing as private citizens to give away our personal data. So don't be mistaken. If you say it's limited to non-personal data, well, think about how much personal data you are willing voluntarily to give away. Now, the Commission says, well, we should share data. Sometimes data comes into existence as the result of sharing. We then talk about co-generated data. And what about AI and the role and importance of human intervention when it comes to sharing data and co-generated data? Now, when you ask questions like who owns the data, because before you share them, you must be in control. You must have some right to the data. And in case they are co-generated, well, is that then common ownership? Is that common ownership as we knew it or know it with regard to, let's say, physical things, or is it something completely different? Is it just about management? Now, what the Commission wants is create what they call a European data space, so a European internal market for data, so the new freedom. And they are setting up what they call common European data spaces for particular areas, like the financial industry, agriculture, and others. And they say that in order to share data, we should have, and then I suddenly wake up as a lawyer, they say, well, we need rules of access to and use of data. I think, which rules? What are you talking about? Well, the rules should be fair, practical, and clear. Yes, but as I said in, I think, one of the lectures that I gave recently, It's easy to agree on a very abstract level on principles that you know, the rules of access to data should be fair, practical, and clear. But what do you mean? What do you mean when it comes to actually wanting access? The Commission also adds that this is not just about business, it's also about governments. And they say sometimes businesses should be obliged to share data with the government for the public good. At the same time, they want businesses to share data among themselves under certain conditions. And we are all familiar with abbreviations like B2B, B2C, etc. But new abbreviations are being used in these papers. G2B, government to business. So government data should be made available for businesses, like meteorological data. Business to business. Businesses should share data. But just how do you want to achieve that? You tell Google that they have to share data? Well, Google is now doing it voluntarily with governments all over Europe, helping these governments to create apps to find out whether we are infected by the coronavirus. So that's an example where Google voluntarily is sharing data, but not with another company, with the government. And then we get to B2G, business to government. But they do it voluntarily. The question is, can they be forced to do so? But it all starts with, well, if you share data, what are you sharing? You are sharing access. But what is access in a legal sense? Now, what AI does, and that is at the heart of the white paper artificial intelligence, is add value to data. So data analysis is faster, is deeper. We have to prepare, the Commission says, for a next data wave. If you look at the figures explaining how many data are being produced in a way in Europe, it's staggering. If we apply that to land registration, what do you have to think of? Well, an example. It is quite interesting for, to give you a very simple example, for removal companies, so people who help you move house, to know whether someone has sold a house or bought a house. So companies like that are interested in houses bought or sold in the area where they have their business. They would like to buy those data. At the moment, this has to be done by contract. But could, under certain circumstances, certain businesses demand access to those data? And what does access then mean? Do you both have access to the same data set? So would you then have two owners at the same time? What does access mean? It's clear, as I told the students, that ownership of data is definitely not the same as ownership of land. Ownership of land is about using it, living on it. As a farmer, you know, you have plants on it, you seed it, etc. With data, it's you use it for economic purposes. So ownership of data is more like management, but you would have co-management. But what are your rights and duties as co-managers of the data? How to do that? The white paper artificial intelligence then says, and then it becomes very abstract again, well, what we should have is findable, accessible, interoperable, and reusable responsible data. So fair. Sounds very interesting, but again, what do you mean? When you share data, can first of all, what are you sharing? What is your right? Is there an entitlement? It's more than contract. It looks like property, but it's not property in the traditional sense of the word. Can a government, can the European Union force us to share data? Do they have, and I look at CIBIT, do they have the competence to tell governments, to tell companies to share data? Or does it all have to be on a voluntary basis? I leave that question open. And at the same time, the Commission stresses that the use of AI and the necessity that data should be shared must, of course, be within the framework of maintaining human dignity and privacy protection. But to me, I then question, well, what's the value of privacy protection if your starting point is that data should be shared, should be reused? We see it in the debate on the apps regarding the coronavirus, because if I go back one step, or two steps, you see that the Commission talks about G2B, B2B, and B2G. But what about person to government? And that is exactly what is going on right now, that the government wants us to share data about our health, which is clearly data that is privacy protected, in the interest of public health. Can a government force us to do that? That's an example of sharing data, and this time not unlike these papers are targeting, because for economic purposes, to create an internal market, but for health purposes. But we also know that these data at the end will be used by academic researchers to develop perhaps strategies to fight the virus or to create perhaps a vaccine, who knows? So what's the borderline between giving up data for public health reasons and giving up data for economic purposes? Can we be forced to give up data? What is the right we give up? Is it ownership? Do we then share ownership? Can I say, I still own the data on my phone regarding my health, but the government is a sort of co-owner? But what do you mean? Those questions are definitely, I can tell you, not answered in these papers. They're being left completely open, and that worries me. So what I think we should discuss is how to legally structure the forced sharing of data. So we have to know, okay, what is the right that I have regarding data? It's privacy, but it's also a private law right. It's mixed. The distinction between private and public law has gone here in this area. That I'm convinced that we should no longer think as a private or public lawyer, we should think as lawyers. The whole debate so far is on business and government sharing of data, but in reality, the debate at the moment is about person to government sharing of data. And why not do that the same with regard to land registration? Why not say, well, a person, well, selling land shares data with the land registry, and that's also a form of sharing data. So why not include P2G in the whole debate about sharing data? A difficulty also is that the data that we have, in fact, is frequently created by people working together. It's a seller, a buyer, working together with an estate agent, a notary, a land registrar. So how to manage co-generated data? So data that is created as shared data from the beginning. I therefore argue that in this common European data space, we should definitely look also at land registration data. So we should not focus on specific common data spaces as now mentioned, but we should look at other data spaces as well, but also be extremely careful. And yes, I know I'm a bit prejudiced being a property lawyer, but I worry about policy papers that force us to share, but don't tell us what the legal framework is. So, and that's the point I wanted to make, and I hope for a very vivid debate, Louisa and Paula. So thank you.
Thank you, Chef. Thank you a lot. This is really challenging, challenging presentation, because this is the future, but the future is already here. And again, what you've been explaining to us has very concrete repercussion on our everyday life. Discussion about apps for tracing people, for resuming work, for opening again the borders and allowing people to travel is there. And of course, all these aspects are intermingled. Who owns the data? How are they stored? What kind of use can be made? How is privacy ensured? So the very theoretical aspects, in fact, have a very concrete everyday life involvement. And I think you were excellent in showing us that behind the curtains of technicalities, not just legal technicalities, but even more technological technicalities, which for the laymen are almost non-understandable, are very big stakes are there. And I think there's also a very interesting overlap with what Siebe was mentioning in his presentation about how we define private parties. I mean, is Chef Van Erp or Luis Antonioli a private party as Google or Microsoft is? Well, in some sense, yes. We are all private parties when it comes to the traditional definition against public law, private law distinction. Are they really? They're not. I mean, everybody is aware that the role that they play is a quasi-public role about information, about political decision and political processing, the data processing, and in fact, in Italy, but I'm pretty sure that's is happening elsewhere too, the definition of these apps for tracing people is done essentially by private companies. Yeah. Of course, there's a public control, public scrutiny, but it's essentially private. So this blurring of the private public is really a major feature of today's law. And of course, the fact that it mingling a number of aspects connected to national law versus international law and EU law makes it even more complex. But I think you managed in a very short time to give a very nice view of what are the stakes there and how this affects our legal categories. So thank you very much indeed for your presentation. I think now we can move on to Hugh. So if Chef, you are able to disconnect your computer from the sharing, then we can ask Hugh to share his.
See how to do that. Oh, there we go again.
we can do it again.
Same problem.
You should have a red button to stop sharing.
Yeah, but the thing is, my screen changed in the meantime again. So
yeah, but you see on the, so now you should have like not the full screen anymore, but you should see the bar, the black bar on the bottom.
Yeah.
And then you should have like a kind of red button, stop sharing. Do you have it?
Nope. Sorry.
But do you see share screen?
No, that's also, it's the same problem as we had before we started. What I will do is I'll try to leave the meeting and then come back.
Let me try and see if I stop sharing screen, whether this takes you away.
It could be on the top of,
Okay.
Yeah, perfect, perfect, thank you.
You're powerful, Luisa.
Done. Look,
you have the power.
Now you can share it. I'm really the powerful man.
Exactly,
yes.
Exactly, there we go.
So be afraid, Luisa can stop you.
Thank you. Okay, so Hugh, are you okay with trying to? Yeah, here we are.
All right?
Yeah?
Yes, thanks a lot.
Good. So you got the floor.
Thank you very much. Well, good morning, and thank you very much to Paolo and Luisa for inviting me to take part. I'm delighted to do so. I only wish I were with you all in person, but that's something much more traditional. Hold on, sorry. What I want to talk about is the impact that European law has had on contract law. Now, of course, we have no single European law of contract. We came close to one, having the Common European Sales Law, until that proposal was withdrawn. But I want to talk about the impact that what we have had by way of European legislation has had, particularly the treaty, the regulations, and the directives. But then I'll move on to talk about the influence of soft European contract law, the principles of European contract law, the draft common frame of reference, the draft common European sales law. and talk in particular about Germany and France. I'm not qualified really to talk about other continental systems, and in particular the reforms that have taken place there, but also to talk about the effect on English law, because I think it's quite an interesting question whether our 40+ years membership of the EU has actually meant that there has been any real influence of European community law on our private law. And then come back to this question that Louisa mentioned at the beginning: to what extent are the laws of contract converging, or are there still many differences, and perhaps what are the reasons for those differences? Now, when we're talking about hard European law and its direct impact on contractual law, well, obviously the competition provisions, which have been mentioned already. We've got regulations, the Rome regulations on the applicable law, the Brussels regulation on jurisdiction, and most recently a regulation on online intermediation services that Paolo's written about, directives. And as you know, they're either very specific or sectoral only. Some of them relate to business contracts, Commercial Agents Directive, Late Payments Directive, and most recently the Directive on Unfair Trade Practices in Agriculture and Food Supply Chains. But the vast bulk of the stuff is in relation to consumer contracts. And the impact on national law has been rather variable. Let me just go back and remind you, though, these directives on consumer law, some of them are more public law in the traditional sense, if I can still be permitted to draw the distinction between public and private law, in the sense that they require member states to regulate particular practices, misleading advertising, unfair commercial practices, and so on. But many of the directives do confer private law rights on individual consumers. Doorstep and distance selling, which of course is now dealt with by the Consumer Rights Directive, unfair terms, consumer sales, and most recently, digital content and digital services. And I'm sure that the listeners will be aware that most of the older directives are what we call minimum harmonization directives, in the sense that member states can give their consumers greater rights. But the more recent ones, the Consumer Rights Directive, the Digital Content and Digital Services Directive, are full harmonization. And the same is supposed to be true of the revamped Consumer Sales Directive, though actually I would argue that there's so many holes in it that it's not really full harmonization. So what impact has it had on, have these directives had on national law? Well, I think it's very variable. It depends what member states had before, depends on the means of implementation in the member states, and the extent to which the member states have used minimum harmonization, sorry, I've abbreviated it to minimum harm, in order to give consumers greater rights. If we look for a moment, for example, at Germany, we'll find that the Unfair Terms Directive had resulted in very little change to German law, because the directive is actually very similar to what Germany already had. In 1976, it passed its Standard Terms Act, and that's all now incorporated into the Civil Code, and it's very similar to the Unfair Terms Directive. That was a catalyst for a very large revision of the German Civil Code. Particularly, they were getting rid of their old law about latent defects, which might give the buyer the right to a price reduction or a refund, and substituting under sections 433 and following of the BGB an obligation to deliver conforming goods, which would, if broken, amount to a breach of contract. So it really resulted in quite a heavy reform of the German Civil Code. What about in the UK? Well, C.B. de Vries talked about public lawyers being the ugly duckling. I'm quite sure that in his case, the ugly duckling will turn out to be a swan. Unfortunately, not all ugly ducklings turn out to be swans. I think at the end of this talk, you'll think that English law is also an ugly duckling and it's turning out to be a goose, but never mind. We had quite a lot of pre-existing regulation. We regulated consumer credit in great detail. We had acts on timeshares, and we had a Trade Practices Act, which dealt with the same sort of thing as the Unfair Commercial Practices Directive. But in other areas, there were really very significant changes because of the directives, particularly the rights given to consumers under the doorstep and distance selling directives. Consumer sales, before the directive came in, sellers in England had the same obligations, but the remedies were very different. We didn't have remedies of repair or replacement. And the Unfair Contract Terms Directive was much wider than our older Unfair Contract Terms Act, 1977, which essentially dealt only with exclusion clauses. But it's quite interesting that actually in the UK, not only did we have major changes as a result of the directive, but in many cases, we then went beyond the directive by what has come to be known by at least opponents of it in the UK as gold plating. When the directives were first implemented, we tended just to copy out the words of the directive. So the regulations which first implemented the Unfair Terms Directive simply copied it out word for word. And the Consumer Sales Directive was implemented by sections in the Sale of Goods Act, which again were pretty much verbatim directive. But in 2015, we tried to straighten everything out and simplify it by our Consumer Rights Act. And that extended the remedies of repair and replacement, not from goods to digital content, and even to the performance of services, which is really quite radical for English law and goes well beyond what's required by the EU. And equally, on unfair terms, we now go beyond what's required by the EU, because Section 62 of the Consumer Rights Act, which is the one that says that terms which are unfair can be challenged if they're not compatible with good faith, applies whether the terms were negotiated or not. So there are significant changes. But what about our general contract law? Because that's what I really want to concentrate on. When these directives started, there was a good deal of speculation that implementation of the consumer acquis into UK law would have a major effect on the general law of contract, particularly the directive on unfair terms, because it was bringing in good faith. And Professor Gunther Teubner wrote a very interesting article where he described the effect of good faith in terms of it being a legal irritant. He said it was a bit like introducing a grain of sand into an oyster. It might have effects within the oyster. And he said that unfortunately, you couldn't guarantee you were going to get pearls. The effect of the transplant would be wholly unpredictable. But actually, that has not happened. And I think the reason is that the UK legislation has been very strictly confined to business to consumer contracts. And the English courts do not translate business to consumer rules into general law. We have had no general reform which would adopt an EU or continental model, big contrast to the German civil code reforms of 2002. And the only exception is that in competition law, we have adopted the EU model for our domestic competition law as well. But that's really the only major exception. What about importation of general principles into English law through case law? Have we adopted EU case law, or have we been affected by the continental laws? Now, most English lawyers are like me. They're lousy at languages and they can't deal with foreign laws directly, but you might expect there to be some importation through the medium of soft law like the PECL. Well, in some areas, and Professor De Vries will be able to talk about this in more detail than I can, but we have adopted in administrative law the notion of proportionality, which was something that we simply didn't have before we joined the European communities. But what about in contract law? Well, I'm going to describe briefly two developments where actually proportionality has now showed up as a matter of contract law, penalty clauses and contracts involving illegality. And then I'm going to move to the big bugbear, good faith. Has that affected English law at all? Well, first of all, penalty clauses. English law accepts that you can agree the damages that should be paid in the event of a breach of contract in advance. And we talk about that as a liquidated damages clause. And that's acceptable, but you enforceable in English law, even if it was negotiated freely between two parties who were more or less equal. What's the distinction between an agreed damages clause and a penalty clause? Well, the traditional test is that to be a liquidated damages clause and valid, it had to be a genuine pre-estimate of the likely loss in the event of breach of contract. Or at least it mustn't be extravagant or unconscionable in comparison to the likely loss. Now, there was some hesitation around that. There were some cases saying that possibly agreed damages didn't need to be a genuine pre-estimate of the loss if the amount was commercially justifiable. But the one thing everybody seemed to agree on was that you couldn't have a clause which was designed to deter a breach by the other party by punishing them. Well, in two cases which were heard together, the Supreme Court has completely rewritten our law on penalty clauses. Upholding as valid liquidated damages clauses, clauses which were quite clearly the case, a business was sold and the seller promised not to compete. And the contract said, if you do compete in any way, the price will be reduced very, very much. Quite clearly not a reflection of the loss that the buyer would suffer, but an attempt to deter the seller from breaking the contract. And the second example was even clearer. It was a consumer case where a consumer was allowed to park in a shopping center car park for free for 2 hours. But if they broke the contract by overstaying or in various other ways, they would have to pay £85. Now, it's quite clear that that was not a loss which was suffered by the other party. But the Supreme Court upheld both clauses, saying that a deterrent clause is perfectly okay if the payee, the party who will be paid, has a legitimate interest in securing performance rather than merely being compensated for breach of contract. And the amount is not extravagant or unconscionable, or many judges said disproportionate to the legislation, totally foreign to us, is creeping into contract law as well. And it's also come into the case of illegal contracts. We have a rule that a court will not hear an action which is founded on an illegal act. And the famous statement on which this is founded was as old as 1775. If from the plaintiff's own stating or otherwise, the cause of action appears to arise ex turpi causa, from a base cause, the court will simply not assist the claimant. Now, how do you decide whether a contract offends the ex turpi causa rule? Well, the traditional approach was that there were a whole series of rules enforced. If it required performance of an illegal act, it couldn't be enforced. If it was intended to be performed in an illegal way, it couldn't be enforced. But the mere fact that I broke the law in performing the contract, the taxi driver broke the speed limit, for example, that wouldn't render the contract unenforceable. The only problem was that the cases simply didn't fit the rules. You couldn't apply the rules and come up with the same results as the actual cases. So in a case in 2016 called Patel and Mirza, the Supreme Court again rewrote the law. This was a case where Patel had paid money to Mirza to place a bet on the movement of RBS shares. RBS, the Royal Bank of Scotland, if you remember, was taken over by the government in the financial crisis. And private information, insider information about what the government was going to do. And he thought he'd be able to bet on the movement of the price of shares. And Patel paid him a large sum of money to put on bets. But actually that information never became available, and Patel asked for his money back. Now, the existing law, the existing rules rather suggested that Patel couldn't get it back. So they did what they normally do when they're trying to overrule or considering overruling an existing case. They got together a 9-judge panel, all of whom held that Patel could get the money back. But the grounds on which they could get it back was a very sharp division. The minorities said, we want to stick with rules, though they then failed to explain what those rules were in any clarity at all. But the majority said, a rules-based approach has not worked. The results simply are unpredictable. Instead, we want to move to a flexible factors-based approach where you will only refuse to enforce a claim if to do so would be inconsistent with a number of criteria. Firstly, you won't allow somebody to profit from their own wrong. And secondly, you must ensure that the law acts consistently. So you wouldn't enforce a claim where there had been some illegality if to do so would defeat the underlying purpose of the prohibition in the first place, or would defeat some other relevant policy. But always you have to ask, would refusing to enforce this contract be disproportionate to the wrongdoing? And incidentally, they all said that normally speaking, you should allow parties to an illegal contract, and they assumed the contract itself in Patel and Mirza was illegal. You should normally give them their money back. So you can see disproportionate is spilling over. Well, what about good faith? Because if you know anything about English contract law, it's that we don't have a doctrine of good faith, whereas virtually every continental country has something very similar. Well, you'll probably know that English law tends not to go for broad standards. It tends to develop, as Lord Justice Bingham put it, piecemeal solutions in response to demonstrated problems of unfairness. But actually, English law very seldom requires one party to have a reasonable regard for the other party's interests. Yes, there is some good faith in English law. Obviously, our regulation of unfair terms in consumer contracts depends on the test of good faith that was developed by the Court of Justice in the Aziz case. And you'll certainly find in property law, if I can spill over into Chef's area for a moment, references to good faith purchasers, good faith buyers. But in that context, good faith simply means absence of knowledge, absence of fraud, if you like. It doesn't mean what I understand the continental doctrine of good faith to require, which is a reasonable regard for the other party's interest. Conversely, and at the other end of the scale, we have some contracts, like the contract between a lawyer and their client, where the other party must put the client's interest first. But that's not what I understand the continental doctrine to mean. So does English law ever require one party to have a reasonable regard for the other party's interests? Well, only in very limited circumstances. Contracts of insurance, where there used to be a duty to disclose, it's now been modified. Contracts of partnership, joint ventures contracts. But that's all. Otherwise, it only sometimes a contract will explicitly require one party to act in good faith, and the English courts will enforce that. But secondly, there are a number of cases where one party has had a discretion under the contract. For example, a lender might have a discretion to vary the interest rate on a loan. And in that case, the English courts have said the discretion must normally be exercised in good faith and not wholly unreasonably. But if you take the two parts of that statement, I think it's fairly clear that they don't mean that the lender must have a reasonable regard for the other party's interest. In this context, good faith simply means it mustn't be done in bad faith. There mustn't be any fraud. So that's very limited. And until about 2013, we could say that actually there seemed to be very little impact at all. And in one case, the House of Lords seemed to reject the whole notion of good faith as a matter of English law. This was a question of pre-contractual liability. There was an agreement not to negotiate with anyone else, which one party broke. And in the House of Lords, it was said the concept of a duty to carry on negotiations in good faith is inherently repugnant to the adversarial position of the parties when involved in negotiations. In other words, it just doesn't fit with our notion of what's going on when parties are negotiating a contract. But in 2013, there was a case which suggested there might be some movement. It's a case called the Yam Seng case, which involved a distribution agreement under which ITC granted Yam Seng exclusive rights to distribute fragrances bearing the Manchester United label in specified territories, and particularly in duty-free shops. Why anybody would want to smell like a football team, I can't quite imagine, but nonetheless, that was the agreement. And Yam Seng claimed that ITC had broken the contract by, first of all, giving false information about when products would be available, and secondly, by supplying other people who were going to sell in domestic, non-duty-free outlets at such low prices that they could undercut the duty-free outlets. Now, it was not argued on the basis of good faith. It was argued on the basis that there must be implied into the particular contract, in order to make it workable, a duty not knowingly to give false information and not to undercut the prices. And the judge held that the first duty had been broken. There was a second duty, but it hadn't been broken. But nonetheless, ITC were liable to Yam Seng. But the judge, Mr. Justice Leggett, went off into a long excursus into whether there should be an implied duty of good faith, and pointed out that there was a lot of academic literature about it, no serious discussion in the cases at all, but that English law, by refusing to recognize a general obligation of good faith, was swimming against the tide. And he pointed to the directives, he pointed to the PECL, he pointed to the Common European Sales Law, and to developments in other common law jurisdictions, some of which have adopted good faith to some extent. He said, however, I doubt that English law is ready to recognize good faith as a duty implied by law, even as a default rule, let alone as a mandatory rule. But he said, I think it can be implied into the particular contract where the contract is a relational contract. In other words, a long-term contract where the parties have not worked out at the beginning what each party is to do in any detail. And there have been a number of subsequent cases applying good faith in that kind of contract. I won't go through them all, but basically the most recent case, a case involving postmasters versus the post office, the judge said that in a relational contract, good faith is implied by law. In other words, adding a new category to joint ventures and partnerships, this notion of relational contract. The problem is, first of all, nobody quite knows what a relational contract is, but secondly, most judges seem very firmly opposed to good faith. And I'm just giving you one slide. Retired, you probably know him as better as the judge who's in charge of the Grenfell fire inquiry, that terrible disaster we had. But he was saying effectively that we should not adopt a principle of good faith. There's a real danger that if a general principle of good faith were established, it would be invoked as often to undermine as to support parties to support the terms in which the parties have reached agreement. And basically, if you look at the key areas where there are differences between particularly the common law systems and the civil law systems, and many of the students will have seen this slide before, English law has not changed at all. And so we have to say English law, basically very little influence. Has there been influence elsewhere? Well, I think the answer is yes, particularly in relation to law reform. That if you look, and also particularly Estonia's contract law, it's quite clear that they took into account to a very large extent the PECL and also the Unidroit principles and the Vienna Convention on International Sales. And in particular, I think we should look at the French Civil Code, which, as you know, was reformed in 2016 with amendments in 2018. Now, the French Civil Code was really to try to bring the old Code Napoleon into line with the case law. So, for example, the duty to disclose, which the courts had developed, was written into Article 1112-1. A party who knows information which is of decisive importance for the consent of the other legitimately does not know the information and relies on the other contracting party. But part of the idea was to make French law more attractive. There was the feeling in France that they were now competing with the principles of European contract law, the Unidroit principles, and indeed the common European sales law, which at that time was still a viable proposal. And it's also very clear from the writings that the PECL and the Unidroit have been very influential in the reforms. And if you look, for example, at the French rules on unfair standard terms, they are virtually the same as the PECL rules, much wider than the Unidroit principles. And they apply across the board. They're not just confined to consumer contracts. These rules on unfair standard terms apply equally to business contracts, as indeed the PECL provides. And also the French, for the first time, as a matter of general civil law, have adopted the doctrine that they call imprévision, we would call change of circumstance. So, it's interesting that this notion of attractive contract law has spread outside English law. There is this idea that laws are competing for business. And it's well known that that's happening. But I think there are very different ideas of what makes a law competitive. I think that if you update your law, well, that certainly makes it more attractive as a model that other countries might follow. And of course, there are many countries, particularly in Africa, where the French law has been, as it were, the model for development. You can say that it also perhaps makes it easier to do business in France. You may remember that the World Bank published guides as to how easy it was to do business in different countries. And the civil law countries scored pretty low on that scoring. Well, maybe bringing the law up to date makes it easier to do business. But whether the substance of the law makes it easier to do business, and in particular, whether the changes make French law more attractive as the law of choice for transnational contracts, I'm not so sure. English law is also very keen to sell itself abroad. We advertise it as the law of choice for international contracts. But I think we have a very different idea of what the law should be doing. We think the law should reflect what the parties wanted, either their actual wishes or their presumed wishes, not rules set by the state. And we envision a different role for judges. Judges should enforce the agreement, not police the agreement to make sure it was fair or make sure the parties are behaving properly. And we're very keen on predictability, which is one reason why we prefer to have particular rules to deal with narrow situations and avoid broad standards. And I think that's because we're dealing primarily with large business contracts. If you look at the English higher courts, they're dealing mainly with heavy commercial contracts between sophisticated parties who are acting with legal advice or are repeat players. They're making the same contract time and time again. And very often the real issue is that the market has gone up and down. And the question is, can one party get out of the contract? Well, in that sort of situation, certainty tends to be more important than justice. And I see not, I'm afraid, convergence. I see increasing of the continent. And I don't have time to go into it today, but there are other areas where I see a hardening of English attitudes, increasing emphasis on the parties being self-reliant, increasing reluctance to hold that terms in business-to-business contracts are unfair. So I would say that actually, despite our membership of the EU, civil law, certainly the Code Civil, and English contract law are not moving together, they're moving further apart. But I want to end with the question that Louisa mentioned in her introduction. Will the effects of COVID-19 have any effect on English law? Because again, in this area, English law is way out of line. The liability, the part of this responsibility to perform and to perform on time in English law is strict. In fact, I would say that it's almost absolute because we don't have a doctrine of force majeure. We do have a doctrine of frustration where the parties are released if a contract becomes permanently impossible. But temporary impossibility is only a defense if it lasts so long that in effect the whole contract does become impossible. And in particular, English law never adjusts a contract or terminates it simply because of hardship or change of circumstance. The fact that it's going to be much harder for you to perform is no defense. The fact that I no longer have any use for the contractual performance, no defense. Now, whether we will have to change our law in the light of COVID, that's a very interesting question. It's not one that I was planning to talk about today, but if you want, I could talk about it during the discussion. But thank you very much.
Thank you very much, Hugh. I don't know whether Louisa wants to say something after.
Just one quick note.
Yeah.
On the last thing that Hugh said. I was listening to.
I seem to have lost everybody.
To the European Law Institute webinar on a change of circumstances and the discussion of the ELI principles.
Yes.
And the thing that struck me most was how diverging the interpretations were.
Yeah.
And I really had the sense that in spite of the fact that there are some principles out there that seems to be common, when it comes into the real application, the divergences are really running very deep. Yep. So I think your concluding speech gives a special flavor to this idea that European integration is also about actually disintegration, and the remark that even by having membership of several decades, in fact, English law has not been converging towards continental standard is not just in practice important, but has very deep, I think, implications for our way of thinking about legal transplant and legal convergence. So thank you very much, and I give the floor to Paola.
Thanks a lot, Louisa, and many thanks to all the speakers who wanted to join us today for this wonderful roundtable. I enjoyed all the speeches, and I think that everybody had the opportunity to learn a lot today. Let me just make like 4 points. I try to make a kind of horizontal overview of the three presentations, but very briefly pointing for principal statements. And meanwhile, I'll invite everyone who would like to present a question for the question time, for the question and answers space, to write a question on the chat tool, so that meanwhile then we can collect and pose the question to the speaker. So just to I think that we can kind of summarize what we have heard this morning in 4 points. The first lecture that we got is that probably we got the title wrong. I mean, we couldn't cite like impact of European law upon the private law, because this blurry line between public and private law makes our reasoning continuously borrowing concepts and rules from public law at the same time. So this is one thing that we should keep in mind. The second thing that I'd like to recall is that whatever the scope of this impact is, whether private or a mix of private and public, there have been different phases through which this impact has developed. Not only different phases, but also different instruments. If I can borrow the initial distinction of Professor De Vries, we can see that all the line drawing phase, when the horizontal and vertical lines were developed and defined, probably European legislation, and I refer primarily to primary legislation, so the 4 freedoms, the treaties, let's say, and the general principle as well, have had an impact more than secondary legislations. However, if we look at what is happening now, and Professor Bills was referring to that as well, I mean, more and more we have secondary legislation like regulations, and the example of out of control also of the GDPR is a confirmation of that. So we more and more have secondary legislation as a legislative vehicle of impact of European law into what we may still conventionally call private law. The phase of color, the color phase, has and sees a huge role for the Court of Justice. We have seen all this in actually all the presentations. Also, Professor Bills was referring to that through the Aziz case, the reference to Aziz case. Then the most questionable one is the phase of probably of harmony. So what really gives harmony to all this impact? And this is very questionable also in the light of what Professor Bill was saying at the end, that actually this harmony is not totally reached, or at least there are still many divergences. Probably to get harmony, we need a major involvement of judicial dialogue also at national level. So we need to turn our face to national judges, and the extent to which these are really involved in the application of European legislation into their cases at national level. Of course, conforming interpretation is very important. The role of the Charter, possibly Article 49 that was mentioned at the beginning as basis for effective judicial protection, is a very important reference, but also, once again, general principles applied by national judges in their controversies. So I think that they are an important medium. And in the last presentation, we have seen the role of, again, general principles like the principle of proportionality as a means for probably giving a higher harmony, to this kind of impact of European law upon private law. Third, I think a consideration that we can derive from today's presentations is what are the factors that are influencing this impact upon of EU law upon private law. Definitely there is a technological factor, a technological dimension. It was very much considered, especially in Professor Van Aer's presentation. But I think it's even, and again, Professor Van Aer presented that very nicely. I think it's even more than just the impact of technology upon society and market. It's the consideration and awareness that there is a higher need for, possibly a higher need for European law, European Union intervention in situations in which we need to face giant powers, and the reference to data-driven powers is very important. So that type of situation in which these giant powers are there, being able to govern massive amounts of data makes the intervention of EU even more important, and even more if we think that you know, the game is not just a game within the European Union, but with third countries. And this explains how the intervention of the European Union could be possibly stronger. And then we have, for example, the GDPR, or the choice of a stronger instrument like a regulation in this case. But still, this is the very last message. Divergences exist. So the impact of EU law upon private law, I mean, is to be combined with the persistent divergence among national private law, and as Professor B was showing at the end, possibly these divergences are not necessarily due to diminish, but probably also to increase in the future. So I don't want to give more space for away from the discussion. So